Good morning. Good evening to all of you. Section 24 of the Contracts Act deals with agreement void if consideration and objects unlawful in part. Here, sometimes what happens is the object, one part of it is legal and another part of it is illegal. Then they cannot be separated from each other or they cannot be severed from each other. Then in that case, the entire agreement fails if the consideration if the consideration and objects unlawful. For example, suppose suppose I let out my house for the purpose of running a brothel, and I also have a share in that. Then in that case, here the very fact that it is going to be used for an immoral purpose is unlawful, and the consideration which is there to let it out or to receive the rent is also unlawful. In that case, Section 24 says the entire it is opposed to public policy and it is void ab initio. Then one more thing is, remember this particular chapter deals with what is called contracts opposed to public policy. Here, if there is a quotation as far as public policy is concerned. There is a quotation in the sense that public policy is like an unruly horse. When you ride astride, you do not know where it carries you. Suppose, let us say, the horse is unsound, and then you mount that particular horse for racing, and sometimes it runs in such a fast speed, it drops you out, and when it will drop you, you do not know. So public policy also is something like that. Here, for example, public policy changes from time to time. At one point of time, we said abortion or feticide is supposed to be banned. But what happened was, I still remember in Tamil Nadu, that's the reason why scanning has been banned now, sir. Where before the child is born, the sex of the child is identified. And if it's going to be a female child, then the question is the child is destroyed in the womb of the mother itself. This is nothing but a cold-blooded murder which should be avoided, and that is the reason why it is said that abortion is today banned and it is illegal. And the second thing is that the scanning should not be done, and scanning is a punishable offense now, and you can be imprisoned, and fine also can be imposed, and your license also can be cancelled. Here, next section is 25. It says agreement without consideration void unless it is in writing and registered, or a promise to compensate for something done or done, or to pay a debt time barred. For example, you go to a surgeon, and then let us say the surgeon, because he's your good friend, he agrees and undertakes to perform your operation. But at the time when the surgeon agrees, no consideration is paid. But later, after the operation is over, the surgeon, of course, I'm talking about Puritan ways, sir. Now those days are gone. Please remember, God forbid that you should not go to a hospital at all, because the question is the amount of expenditure is required, and the time at the time when you get admitted, you have to pay the advance, and unless you pay the advance, they will not take you to the hospital. So the question is, these are all things when things existed there. People believed each other. The surgeon believed the patient believed the surgeon, and services were rendered that way. But for past services which has been rendered, suppose let us say the patient uh, promises to compensate the surgeon for the operation and pay his charges. This is enforceable, but an agreement without consideration is void ab initio. But in case past services are rendered for which you agree and undertake to compensate the person concerned, it is enforceable. And it is also enforceable. Please remember, I also dealt with it by saying, so the question is, suppose let us say a time bar debt. Please remember, morality and legality is entirely different. Morally, I may be wrong, but legally, I am correct. So the question is, suppose I agree and undertake to pay a time bar debt, even assuming it is barred by limitation, the question is, it is valid consideration. Then suppose you as an advocate Then a client comes to you and seeks your professional advice. Then you use your skill, understanding, reading the books, and also the subject, and advise him properly and put him in the right step. But the client doesn't pay you immediately, doesn't have the money to pay you immediately. Then in that case, what they suppose the client says, sir, for out of what all services you have done to me and enabled me to succeed in the litigation, I'm going to pay you the fees. Then even if it is time barred, even at the time when you undertake the brief, it is without consideration, then it is enforceable, provided you are going to be compensated for the fee services which you have rendered to a particular person. This is what Section 25 deals with. Then, as far as past consideration is, here, for example, suppose your institution engages you in a particular case. Let us say the bank engages you. Please remember, the bank does not pay you the entire fees in the entirety. First, I still remember, because having been a bank advocate myself, 25% of it is paid at the time when you file the suit, 25% is paid at the time when the issues are settled, and the other 50% is paid when you pass on the decree and succeed in the suit, and then give it to the bank, and the bank pays you the remaining 50%. Here also, past consideration comes into view, because the question is, immediately the consideration is not passed. Part of it is passed, but rest of it is paid in stages. Then in that case, Section 25, though an agreement without consideration is void, then even then to compensate or compensate a person for the past services, uh, is past services is quite valid under Section 25. Yes. The next, sir, Section 26 is restraint of marriage. As far as restraint of marriage is concerned, sir, there is a custom in most of the houses, most of the families, that they don't want the property to go outside the family. And one of the ways of keeping the property in one's own family is to enter into marriage alliances within relatives. For example, you have got a son, your sister has got a daughter. Then you give your son in marriage to your sister's daughter. And sister has got a son, and you have got a daughter. Then you give your daughter in marriage to your sister's son. In that way, easy పుచ్చుకోవడం అంటారు చూడండి, అది. So, but the question is restraint of marriage. Suppose there is a restraint imposed that you shall not marry throughout your life, you shall remain a bachelor, and you shall always serve the old people. The question is, such a restraint which is imposed, which imposes fetters on a person's personal right, is void and it's not enforceable. But please remember, these are days when the parents will have to compromise with their children. Nowadays, it's not gone are those days when the parents show the boy. Now it is said the girl herself selects the boy. There is a dating also, like Western countries. For 2 years they go about together, of course, except not having sex. Perhaps that also is possible. Then once they agree with each other, their mentalities agree, and they have that courtship. And during that period, they agree to get married. Then in that case, the question is, please remember, nowadays you have to compromise with certain principles. You cannot say that I am a Hindu, my son should marry only a Hindu, or my son is a Christian, he should marry only a Christian, or I am a Muslim, he should marry only a Muslim. If you do that, what would happen is there will be runaway marriages, that son or daughter gets unidentified with your family, and your entire relations get cut off. That's the reason, sir, why life is full of compromises these days. Gone are those days when children used to listen to what their parents say. So this is any restraint that is imposed whereby a person's freedom to get married to anyone he likes, of course, only to a female, is unrestricted. And if any restraint is imposed that he shall not marry outside the community, such a restraint is void. Then, sir, the next one is restraint of. Then next one is restraint of trade except partial. Here, this is very important, sir. Here, what happens is, suppose, let us say, I am having a super bazaar in a particular prominent area, and there is no super bazaar at all in that particular locality. The people from the locality flock to my shop and purchase groceries from time to time. I also give them the various services like online, like what is called online delivery, home delivery, and so on and so forth. Various discounts are also given. With the result, what happens is my business gets prosperous. Then let us say one of my partners is also with me, and let us say they enter into an agreement. So long as we are in partnership, as far as this particular business is concerned, we shall not engage in any trade which is similar or identical to the trade which we are presently carrying on. Such a type of restraint is definitely void, but a partial restraint can be imposed, whereby it is said that you shall not have your shop or you shall not carry on business similar to that of the business with whom you are engaged within a particular periphery, within a particular radius, so that the people from my shop or the clientele from my shop, the goodwill which I have earned in the particular locality does not vanish because there is cutthroat competition. Suppose I give a product for 500 rupees. I'm the person who's a rival, who is part of you earlier, he'll give it to you for 300. Anyone will purchase it for 300 rather than buying for 500. Ultimately, what happens is all the customers of the parent company with which he is working flock to the shop of the. That is the reason why partial restraint can be imposed. This is very, very common, sir, as far as IT industry is concerned, whether it's TCS, Wipro, Infosys, Cognizant, and other, or let us say Novartis, or any other IT company. There they ask you to execute a bond for a period of 2 years. You shall not leave the services of the company, and you also have to give the guarantee of your father or any relative that in case you jump the employment and then join some other company, then in that case, whatever salary is paid, whatever training money is expended to you for you, that is sending you to foreign countries, getting you trained in those particular skills, you will have to forego that amount. These type of restraints are now imposed by the court itself by saying that such a restraint is only a partial restraint. The question is for a 2 years period when the company spends so much on your training, so much on your gaining experience, and also gives you all the facilities. You shall not turn treacherous to the company, but you shall serve the company for that bond period. That is the reason, sir, when you want to join a new company, also the new company insists on what is called NOC. NOC means no objection certificate. You have to get the relieving order from your parent company in order to join the other company. So a partial restraint can be imposed, whereby the rights of restraint can be imposed, whereby within a particular periphery you cannot carry on business or you shall not do anything similar to that of the other person. This is what section 20, 27 deals with. Then 28 is restraint of legal proceedings. Here, legal proceedings. What do you mean by restraint of legal proceedings? Suppose, let us say, you are indebted to me, you execute a promissory note in my favor, you borrow, let us say, 50,000 rupees from me, execute a promissory note and receipt, and then you cannot go to court and say, sir, don't file any case based on that promissory note because that promissory note is null and void. The question is unenforceable. Please compel the other side not to file any suit. Or let us say I want to launch criminal prosecution against you for some offense which you have committed. You cannot enter into an agreement or you cannot restrain me by saying that you shall not go to the court and enforce your legal remedies, civil and criminal. And this is what is prohibited as far as the Contracts Act is concerned. Then what next we go to what is called except arbitration. Arbitration means the word arbitration comes from the word arbitrate. Arbitrate means middle, or come in between. Suppose there's a dispute between two rival parties, there's normally a clause included in the agreement itself to say that in case of any disputes or differences between the parties, the jurisdiction of the civil court is barred and they have to submit themselves to arbitration. One such clause is there for arbitration. No doubt it is a restraint, I agree. But still, the question is unless you exhaust that remedy of naming your arbitrator, calling upon the other side to name its arbitrator, and have a third person also as a referee, and then submit yourself to the arbitration and fix up the agenda and then get the matter decided accordingly. And without that, you cannot go to a civil court. That is the reason, sir. Section 8 of the Arbitration and Conciliation Act of 1996 says that the question is at the earliest available opportunity, you as a defendant, when you get notice from the court or summons from the court, you have to take that objection by saying, sir, under Section 8 of the Arbitration and Conciliation Act of 1996, a civil suit is barred because there's a clause for arbitration. Then there is one clause called Section 9, which talks about prohibitory orders or preventive orders. Injunction can also be obtained from as far as Arbitration Act is concerned, but it is operative only for 3 months. Then the next one is Section 11. Section 11 says that in case you want an arbitrator to be appointed, the only authority which can appoint an arbitrator is the High Court under the acting under Section 11 of the Arbitration Act. So, except in cases of arbitration, mediation, lok adalat, so on and so forth, the question is any type of restraint which imposes fetters on you not to approach a court is void. Then next one is uncertainty. Uncertainty is you do not know, sir, when it will happen, when it will not happen. There is no control over the time. There is no control of the place. There is no control about the performance. You do not know whether the uncertain event happens or does not happen. Then in that case, if it is uncertain, it is also void. And then next one is wagering contracts. Wagering contracts means where there's a chance of one person to win or chance of another person to lose. There is a chance of both the persons losing, or there is no certainty about winning or losing. Then in that case, such a contract is supposed to be what is called void. For example, suppose you say it is going to rain today. Suppose I predict that it's going to rain today. Then let us say you do not know. Please remember the IMD also, which gives you the forecast on the day when they say it is going to rain. It will not rain. When they say it will not, it will rain. It will not rain. So the question is, it depends upon uncertainty. One uncertainty is there. The question is, the contract is void. Then the question is, except horse, please remember, now the government has become a very big businessman. Please remember, you're now hearing about betting in cricket matches, IPL, so on and so forth. Horse races. Horse races. Please remember, no one will play horse racing. Bet on a horse unless you have a chance of winning. But the question is whether you are going to win or going to lose, or you make a big research about it. What is the height of the horse? What is the weight of the horse? What is the height of the mother? What is the weight of the mother? How many races it has run? Who is the trainer? Who is the jockey? And whether if I bet on this particular horse, whether I'm going to win a prize, please remember it is a wagering. Please remember we only take a chance, but the government gets its revenue. That is the reason why horse racing, lottery, crossword puzzles are not banned. It is quite legal. It's not a wagering contract. Though in the literal sense, it's a wagering contract. The question is the bar does not apply. Here, the question which you have to remember is even if I participate in the races, I win the jackpot, the government gets its revenue. At the time when the entire amount has to be paid, 30% of it is deducted as TDS, that is at source itself, and you are paid only 70%. In a crossword puzzle, also suppose you win, the 30% is deducted and 70% is given to you. And please remember, in your YouTube, etc., you get so many offers. But please remember, the question is subject to taxation. The question is at source itself, it is deducted. That is the reason why the government has not banned it. Though it amounts to a wager, it is a valid contract. This is what all we have done yesterday, sir. Today we are going to the other aspect called contingent contracts. I'll only start with this. It's a very small chapter. With that, we'll close. Section 31 deals with what do you mean by contingent contract? Contingent contract means it is depending upon the happening or non-happening of an uncertain event which may happen or which may not happen. Contingent, it depends upon that particular condition which has to happen or which should not happen. Then such a contract is supposed to be a contingent contract. Here, as far as contingent contract is concerned, it is what is called subject to a condition being fulfilled. Only when that condition is fulfilled, or only when that event happens or does not happen, then the question is the fruits of the contract can be enjoyed. Suppose the event happens, then the contract is enforceable. Suppose the event does not happen, the contract fails. That is what section 31 to 33 deals with, sir. Then, when contract contingent impossible, it is the future conduct of the party. Here, when the contingent contract becomes impossible. What do you mean by impossible, sir? Suppose you say, I asked my colleague Mr. Kalyan to walk 100 miles within 5 minutes. It is not possible for any superhuman, any human being to walk 100 kilometers within 5 minutes. The question is, even if you have the biggest runner, a Olympic champion, also you cannot run, you cannot complete the race within 5 minutes. Or let us say there is a contract between you and me that I should touch the sky with my little finger, and if I touch the sky with my little finger, I'll be compensated to the extent of 5,000 rupees. It is an impossible event which is contemplated under the terms of the contract, and to perform an impossible act, the question is, it is not enforceable and it is void. But sometimes what happens is, that is, suppose the event should happen within a particular time. What do you mean by that? That means within 5 minutes, I will have to walk 100 kilometers and then complete the race. Or I must touch the sky with my thumb finger. And if I do it within 2 minutes, I will get the reward. Such a contract is absolutely absurd. Though it's a contingent contract, when does a contract become performable, sir? Only when I touch the sky with my little finger, or only when I complete that 100 kilometers within 5 minutes. It is it is humanly impossible. Suppose I ask Mr. Kalyan to walk 100 kilometers within 5 minutes, even assuming he goes for a walking race, or he puts his clutch or skis and then skis on the road, he cannot complete it within 5 minutes. It is impossible of performance. Again, suppose I say, you have to touch the sky with your little finger, thumb finger, and we should do it within 2 minutes. That is practically impossible. These impossible conditions which are imposed and a contingent contract is made, the question is, contingency fails, the contract also fails. Then the question is, agreement contingent to impossible events void. As far as impossible events are concerned, if any agreement is made regarding that, and if any contract is made regarding that, the question is, it is not enforceable and it is void and unenforceable under the law. This finishes the chapter of contingent contracts. Then, sir, my admin wants to address you, sir, before we move further.
Good evening, as an less staff, less members are there. I think about 12 members are today as of now. Maybe we'll continue the class tomorrow, not as of now, because people are missing certain sections and other aspects. We'll see you tomorrow again. Any objections, any questions from your end, please go ahead. Any questions from your end? Anybody? Right. Maybe today. Sir, please tomorrow repeat once again. You repeat once again. Anuradha. We will definitely consider your notes, madam. We will definitely try to do it, but ensure that all the strength is proper. That's the only request from our end. Thank you. See you again tomorrow. Bye-bye.